Good afternoon, everyone, and welcome back to our weekly webinar series. And today's topic is with respect to the NCLAT, recent NCLAT judgments that have come in. And we have already shared the list of judgments that we are planning to discuss today as part of our banner with all of you. And without wasting any further time, over to Anil sir for taking it forward.
Thank you, Ankit. I'm really happy to say that we have 24th episode today, weekly episode. Although even before that, we've been sharing our experience and knowledge with all our listeners and viewers. But this 24 continuous weeks, even if we were traveling in between, but then yes, we maintained this 1 p.m. Slot 1 to 2 for a collective learning process, and we hope that we continue this. We have in the past, in the last couple of weeks, we have deliberated on the various regulations notified by IDBI, and those participations were huge because that was something which was required by all the persons having some interest in IDBI or IBC. But then today also the NCLAT judgments are really important because there are a few judgments which are now setting a trend, and we would like to collectively learn that this is the trend, and as insolvency professionals, as lawyers, we should see that yes, such kind of applications may not be filed. So sharing my screen again, the format would remain the same, that we collectively will deliberate on the judgments. If there are any questions, that should be given in Q&A tab, and we'll take up the questions at least twice during the 1 hour part. So going to the sharing screen. So we'll just Ankit, is it visible?
Very much.
So these are the 7 NCLAT orders that we are going to discuss today. Some orders are kind of repetition of various other orders. So we will actually try to say that this is something which is a trend, and we should consider this as a law now. Although in some cases, I still feel that the law and the NCLAT judgments are having some clash of interest. I'll discuss that. So we'll take up this first. Haryana State Industrial and Infrastructure Development Corporation Limited versus RR Technoplast Private Limited, judgment dated 6th September, and it was given by Justice Anant Vijay Singh and technical member Ms. Shirisha Marla. Now, the judgment is, I think it's a very common scenario in most of the liquidation cases or CIRP cases, where the land owning agencies, where the industrial development corporations of state, they are not agreeing to the provisions of insolvency law. This is a case where the leasehold property, the leasehold land was sold, or even I believe this was also kind of a freehold. But yes, I still feel that HSIIDC, they do not have freehold properties, but they have all leasehold properties. So maybe it is not properly captured. So the liquidator, in fact, received full amount of the auction, issued a possession letter, and sale deed was also executed, and sale certificate was also issued in the venue. The bidder, in fact, wrote and submitted all the documents to HSIDC, intimating the auction purchase and also seeking mutation in favor of the buyer. Now the HSIDC raised a demand of 4.46 crores, saying that these are the amount payable to HSIDC towards water storage charges and additional interest. Now, in this particular case, this claim was also filed by HSIDC, even in Form B during CIRP, and nothing was payable to HSIDC as the secured creditors were much higher and the liquidation value was not due to the operational creditors. The auction purchaser preferred application before the adjudicating authority, seeking directions to appellant to acknowledge and record the transfer of ownership in the name of the auction purchaser. The application was allowed. So when the application was allowed by the adjudicating authority, then HSIDC filed an appeal before the appellate authority. And the question of law in this case was that the successful bidder in an auction conducted as is where is basis is he liable to pay prior period dues attached to such auction property when the company is in liquidation and the dues were claimed as operational debt before the liquidator. Now, see, like in case let us see the contentions of the appellant. The contention of the appellant was that the appellant has first charge on the property against any outstanding recoverable dues. And again, I think this is very important fact, and this is very important argument of HSIDC that the appellant has first charge on the property because of their agreements against any dues or anything which is recoverable from the buyer or from the owner of the property. Now, whatever way the assets are being sold, we are very clear that the buyer is not supposed to pay anything. The buyer is free. Buyer is completely free, and the buyer will definitely take the asset on a clean slate. However, the HSIDC argued that the clean slate process, the concept is only applicable in resolution processes and not in the liquidation processes. That's not clear. That was not considered as appropriate by appellate authority. Even this HSIDC, the appellant also referred to the Supreme Court judgment in Telangana State Southern Power Distribution Company versus Shirigda Beverage, and where it has been submitted as an auction purchaser, bidding is an as is, where is, whatever there is, and without recourse basis. The purchaser would have inspected the premises and made inquiries about the dues in all respects. And as there is a specific mention of electricity dues as liability of the purchaser was clearly put to notice in this behalf. Hence, it was held that the liability to pay electricity dues exists on the purchaser. Even in the case of the dues raised prior to auction are liable to be paid by the auction purchaser, has to be examined on the touchstone of the ratio of the Honorable Supreme Court judgment in the case of Committee of Creditors of SR Steel versus Cheema Gupta, and on the principle laid down by the Supreme Court in Ghanshyam Mishra and Sons Private Limited versus Agriwise. Now, in these two things, SR Steel and Ghanshyam Mishra, it was the concept of clean slate was discussed, and it was said that the Hydra head popping up is not something which is acceptable for the buyer or for any resolution applicant, and also the buyer or the resolution applicant should take it over as clean slate. And however, in this Telangana State Southern Power, it was held that the liability to pay electricity dues exists on the purchaser, because it was mentioned, that was a different fact, that it was mentioned that the electricity dues would be there. See, even like my understanding is, now the contention of the successful auction purchaser, the successful auction purchaser is a bona fide purchaser and now cannot fasten with the liabilities relating to pre-sale confirmation. Then again, the auction buyer said that the adjudicating authority confirms with the principle of doctrine of clean slate that it is settled law and that post admission of the liquidation, the auction purchaser is not liable to discharge the dues related to the property. Once the sale is confirmed, prior period dues of municipal authorities are to be discharged by the liquidator out of sale proceeds, and the auction purchaser cannot be settled with any further liability. Now, let us see what exactly the liquidator said. The dues of the secured financial creditor against the corporator was much higher than the proceeds from the sale of liquidation asset. Therefore, the dues of the appellant herein could not be paid by the liquidator on the liquidation process. Now, my understanding is that the one error was made by HSIDC because they should have claimed their operational debt as a secured debt. They should have claimed their operational debt as secured debt. In fact, we have handled such cases in Chhattisgarh State Industrial Development Corporation. There we have somehow, because of this clauses in the agreement, that the State Industrial Development Corporation would have the first charge on the land on against any dues. So the first charge definitely makes it a security interest. So in this case, HSIDC has not claimed it as a secured operational creditor. Therefore, they suffered. Otherwise the distribution to HSIDC would have been a pari passu with the other secured creditors, maybe financial creditors or operational creditors. It should have been proportionate. In fact, what we've done in this Chhattisgarh Industrial Development Corporation, that the adjudicating authority could not decide, and adjudicating authority said that in case you consider them as a secured operational creditor, and then the Chhattisgarh Industrial Development Corporation also agreed. Similarly, in this case also, HSIDC should have submitted their claim as secured operational debt, and they should have claimed pari passu with the other secured creditors. However, since they did not claim and the liquidation process completed, sale certificate was issued, sale deed was executed, now in this case, they could not recover their money, and the adjudicating authority had to dismiss, and also the appellate authority had to dismiss, because the distribution has actually been made. It is not possible now that the claim can be modified after everything has been done. So this was the case. However, my advice,
so I believe there are two different issues, right? One issue is that is this amount claimable from the resolution or the buyer of the property? So clearly, all litigations today say that there is no possibility to have the buyer pay additionally over and above what he has paid to the liquidator or the RP and all that. But then when it comes to distribution, there again, the question is still there, that when it comes to the state tax officer judgment or the other judgments where operational creditors due to some agreement have a secured status, there again the redistribution will happen, and there maybe the banks of the country need to relook at all the mortgage documents that they have to understand if they have the loan first charge or not on the company's assets.
So even this, I think you rightly referred to state tax officer versus Rainbow Papers Private Limited, a Supreme Court judgment again in the month of September 22. That kind of spirit is applicable because the agreement says that they would have first charge. They did not claim in their Form B as a secured operational creditor. The sale process completed, distribution made. Now the appellate authority and the adjudicating authority, they had to say no. Now, I think originally the HSIDC should have claimed it as secured operational creditor. So the NCLT, the appellate authority says in this case, once the liquidation sale has been completed and the certificate of sale has been executed, and followed by handing over possession to the auction purchaser, any claim related to such property for dues prior to the auction cannot be raised against the auction purchaser, specifically when the company is in liquidation and the dues were already claimed by the said party as an operational creditor during CIR. The scope and purpose of this code and the ratio of the judgment is to be interpreted in its truest sense, that is not to saddle the purchaser with any hydra head popping up. Because this hydra head popping up again is the Swiss ribbon judgment, where the Supreme Court has said that if a hydra head pops up every day and the successful resolution applicant one head is chopped, another head will pop up. So that kind of scenario, like one claim is settled, another claim will pop up. That kind of scenario is not accepted in IBC. Auction purchaser cannot be made liable for any dues arising on the property before the purchase of said property is in this clause. Appellant has already approached the liquidator by filing in Form B, and the liquidator has intimated to the appellant that there is no amount left for the payment to any operational creditor. Hence, the auction purchaser cannot be made liable for any dues arising on the property before the purchase of said property in this clause. So this is very clear that there are other judgments also, that the State Industrial Development Corporation, they can claim as operational secured operational debt in case, because their agreements are like this, and the liquidators and the RP should admit them as secured operational creditor. And however, in this case, it was not done. But however, this judgment as such, in the absence of their claim, the judgment is absolutely fine. So Ankit, I can see one question, but then we can move on to the another judgment.
Yeah.
Which is
proceed.
Which is Shri Alok Kaushik, resolution professional of Chima Spintex versus Chima Spintex, and this is a judgment dated 5th of September 2022, given by the chairman, sir, Justice Alok Bhushan, and the technical member, Mr. Barun Mitra. Now, this particular judgment is regarding, because there are many such cases which has happened before also. Petition under Section 9 was admitted and the IRP was appointed. Before the formation of the COC, the OC and the corporate debtor entered into a settlement. Now, once this kind of a settlement is submitted, IRP had to file the application to the adjudicating authority for withdrawal. However, in the very first hearing, when there was nothing, the stay on the CIRP proceedings was not provided in the order. The AA had not put a stay on the CIRP proceeding. Therefore, the interim resolution professional proceeded to constitute COC. So once the COC is constituted, then there are other expenditures like taking control, custody, deploying security guards, and also some other resources, because the company has to be managed by the IRP as a going concern, and the management, all the bank account has to be taken over, all the GST returns and INC 28 has to be filed. So this is what IRP did, and the expenses were incurred by the IRP. However, while this withdrawal hearing, while hearing the withdrawal application, the adjudicating authority made erroneous remarks about the conduct of IRP, observing that since withdrawal application was filed by the IRP continued with the CIRP process and incurred expenditure which are unjustifiable. Now, there are confusions, like as far as the IRP is concerned, one hand IRP is told that you have to comply with the timeline. The application is submitted, that doesn't mean that the application would be accepted by the adjudicating authority. And however, in case the COC is not constituted within the stipulated time, then the IRP can be questioned by IDBI that you have not worked as per the timeline. Further, the adjudicating authority also finally classified that some of the expenditures incurred by the IRP are essential and some of the expenses incurred by the IRP are not essential. So therefore, IRP was paid only the cost ratified by the Honorable Adjudicating Authority as essential. However, in this particular case, it is also very important to know that all the expenditures incurred by the IRP was ratified by COC. So once the expenditures were ratified by COC, and it was the duty of the IRP to proceed to constitute COC, then the adjudicating authority classified some expenditure as essential, some expenditure as non-essential. So this is something which is the issue which came before the appellate authority, whether the continuance of CIRP proceedings by IRP was justified when he himself filed withdrawal application, whether the adjudicating authority erred in disallowing certain CIRP expenditure claimed by IRP, treating them non-essential, whether the remarks disapproving the conduct of the IRP stands to reason or not. So these were the three issues and the arguments from the appellant, like the appellant is the IRP. So the IRP says that this mere filing of the withdrawal application does not lead to automatic stay of CIRP proceedings, and therefore IRP is duty bound under CIRP regulations to complete the CIRP proceeding, and for this purpose he had to engage other professionals and deploy resources, thereby incurring expenditure. Then the IRP says that the CIRP cost and the IRP fees was placed before the COC and it was duly ratified. Now, the classification of activities undertaken during CIRP as essential and non-essential by the adjudicating authority is an artificial creation which is not in terms of the IBC. IRP appeared regularly before the adjudicating authority on each assigned date, which testified that he had been diligently pursuing the CIRP withdrawal application filed by him. Despite the best possible efforts by the IRP, the adjudicating authority has been wrong in appreciating the conduct of the IRP and made adverse remarks without cogent reasons, and which should be therefore be expunged. That was the appellant's argument. And the NCLAT finally gave a mixed judgment, mixed judgment in the sense that almost agreed with the adjudicating authority. Number one, the NCLAT finally held that the CIRP withdrawal application before the adjudicating authority was a known factor, and IRP should have pursued for clear directions and guidance rather than pushing forward the process, incurring added CIRP expenditure. So in this case, the appellate authority, NCLAT, thinks that IRP should have taken clear direction from the adjudicating authority. Like there was no stay and there was a natural legal obligation by the IRP, but now the NCLAT says that the IRP should have taken clear directions from the adjudicating authority whether to continue the process or not. NCLAT also decided that the adjudicating authority used terms like essential and non-essential as easy reckoner and not acted or intent in any manner contrary to the form and spirit of IBC. The adjudicating authority said that in this Chima Spintex case, whatever has been held by adjudicating authority, that should be used as easy reckoner, that what kind of expenditure should be incurred and what kind of expenditure should not be incurred. That should be used as easy reckoner. IRP continuing with the CIRP without making adequate efforts to seek pointed clarification from adjudicating authority on whether to proceed with the CIRP or not does not reflect well on his conduct. So therefore, the NCLAT thinks that the IRP should have filed another application or in the subsequent hearing should have raised this issue, whether he should continue to constitute the COC, whether he should continue to take control and custody of the asset, whether he should continue to maintain the company as a going concern, whether he should continue to manage the fund flow of the company, whether he should continue to operate the bank accounts of the company, whether he should continue to file the GST returns of the company, whether he should continue to file TDS returns of the company, because this process of withdrawal may take 3 months' time. And the suspended directors are suspended directors, they have no power. So in case of any litigation which is going on, the IRP has to give mandate, IRP has to appoint lawyers. So all these lawyers, chartered accountants, whosoever has been appointed, that means that the special directions should have been taken whether the process has to be conducted or not. This is what is the opinion of NCLAT as well as the adjudicating authority. Then further it is said that the IRP chosen to mechanically proceed by taking the plea of adherence to CIRP. IRP may be technically correct, but the same cannot be contested. Contested means approved. So the NCLAT could not approve this process. NCLAT could not understand whether the IRP should continue. The NCLAT said that he should have taken the direct, the specific opinion from the adjudicating authority whether he has to continue or not. Therefore, the appeal being devoid of merits was dismissed. So the appeal filed by the IRP was dismissed. No order as to the cost was passed. Ankit, any comments from your side on this?
So
Because
practically,
there are many cases with us also.
So practically, like many cases which are with us also, like when we file this application before AA and ask them to withdraw the CIRP, like the CIRP doesn't go into a complete cold storage, but we would normally just have COC meetings and simply, pass very, very small expenditures which are essential. We won't go ahead with the complete CIRP, or is that how we deal with these such cases?
No, see, there are earlier judgments where it has been held by the adjudicating authority that there is no direction to you that you should stop CIRP. So there are certain cases where the withdrawal application was rejected. In those circumstances, then they should be when this IRP will constitute the COC after 3 months, then he would actually face the non-compliances. So IRP is presently not really understanding what is his duty, what should he do. There are earlier some judgments, because even in a couple of our cases also, the cost was not paid. Although the adverse comments were not made, but then the costs were not paid. And it was somehow it was a loss to us. One of our partner, he did this, and it was a loss to IPE, it was loss to IP, and all the expenditure, whatever was incurred, even the security guard, that was not given, and the case was withdrawn. So I think we all have to be very, very careful, and in case no such.
So what is the solution then? Another solution then is that in case a withdrawal application is filed, along with it, either a stay application is filed or some kind of a report is filed to the NCLT that while the case is pending for disposal at their end, the RP is continuing to incur these costs or continuing the CIRP in absence of a stay. Like if this information is filed with NCLT, will that help?
No, I think now this Chima Spintex case, there is a ready reckoner available. What is essential and what is not essential. So every IRP should refer to this Chima, because that has also been upheld by the appellate authority. Yeah. Once this essential and non-essential has been upheld by the appellate authority, that means that actually can be considered as present law. So the essential and non-essential categories bifurcation can be taken from Chima Spintex, and accordingly the IRP should function, and also IRP should file a specific IA for seeking direction, whether he should continue or not, whether he should proceed in CIRP or not.
But where such direction is not received, should he continue or should he not continue? He should continue.
Then he should go by the essential and non-essential. I think that's the only thing that we can say for the time being, because see, because of the capacity of the NCLT, the cases are not coming up very fast. And even if these are even the withdrawal applications are listed at the end of the board. So in maybe in 1 or 2 hearing, it doesn't even come up for hearing. So therefore, it may take 2, 3, 4 months in withdrawal. So what the IRP is supposed to do, I think IRP should refer Chima Spintex, see what are essential, non-essential, and also file a specific application whether the CIRP should continue or not. That kind of direction would be required. Because see, the difficulty comes when this withdrawal application is rejected. Those kind of difficulties, then the IRP would be in trouble.
Yeah, got it. Let's proceed.
Let's proceed to the third case, Shailesh Verma, RP of Lavasa, Corporation Limited versus Maharashtra State Electricity Distribution Company Limited. Again, a judgment on 2nd of September 2022 from Chairman Sir Justice Ashok Bhushan, and it's a 3-member bench, and Justice M. Satyanarayan Murthy and technical member Varun Mitra. It's a very, very regular kind of issue in this case. The Lavasa, they had a distribution franchisee agreement, and the adjudicating authority directed the respondent. Respondent in this case is Maharashtra State Electricity Distribution Company. So the Maharashtra Electricity Distribution Company, that they were directed by the adjudicating authority not to maybe not to terminate the distribution franchisee agreement and continue to supply uninterrupted electricity to the corporate debtor. RP was directed to pay outstanding dues during CIRP period within 90 days. Agreed by the order insofar as it directed the RP to pay the outstanding dues of the CIRP period, the RP preferred this appeal. Now, the RP was not comfortable that there was an order that the respondent, like the electricity distribution company, it was directed to them that they would continue the supplies. However, the current dues have to be paid. But the RP was not satisfied that the current dues has to be paid. RP was saying that the payment of electricity dues cannot be demanded by the respondent since they are part of the CIRP cost and can be paid only at the conclusion of CIRP. That is, after the approval of resolution plan. According to my understanding, the RP should not have done this. RP should not have filed this appeal. RP should have adhered to one, it has been assured that the power would not be disconnected. However, the payment of the current dues has to be made. However, the RP, maybe that the RP was not having a requisite funds, so therefore the RP did that. So the respondent, the electricity company, said when the corporate debtor has opined that supply of electricity is unessential and it is to be continued by the respondent, it is also under obligation to make payment of electricity dues of the CIRP period and directions issued by the AA to make payment of outstanding dues. The appellant cannot enjoy the benefit of directions of one part because the directions were two. One direction was that the electricity supply will continue. Second direction was that the RP will pay the current dues within 90 days. So in this case, the appellant, like the electricity distribution company, said that you cannot choose to comply with the one direction and not with the other. And in this case, the NCLAT was very clear, and it is in fact a repetition of various other judgments where it has been held that the section 14(2) as contained in the code only provided for supply of essential goods or services in the corporate debtor contained in the indication that the supply of essential goods or services to the corporate debtor shall not be terminated or suspended or interrupted during moratorium period. It is a substantive provision that when IRP or RP considers the supply of goods or services critical to protect and preserve the value of the corporate debtor, the same shall not be terminated or suspended or interrupted during the period of moratorium, except where the corporate debtor has not paid such dues arising from such supply during the moratorium period. It is clear that in the event on non-payment of dues, as per section 14, subsection 2, capital A, it shall always be open to the respondent to terminate, suspend the supply of such services. Hence, the appeal was dismissed. So I think this law is kind of well settled now. Like in case of essential services, the supply has to continue and the past dues has to be submitted as a claim. However, the current dues has to be paid. There is no relief for the current dues. If the current dues are also not paid, then I believe it is very clear by this NCLAT judgment in the case of Shailesh Verma versus the Maharashtra State Electricity Supply Corporation that the supply companies can discontinue. Therefore, the appeal filed by the RP was dismissed. So, Ankit, any observation from you, because this is a very, very regular like
it's a very regular judgment. I think it's I have a feeling that there might be dearth of funds, as there is in many CRP cases where you are availing essential services, but you are not having money to pay for them. and maybe this RP might have done this or filed an appeal at the instance of or under influence from the COC, which might have made this statement that we only need to pay this at the end of the period, because what is required to be paid at the end of the period is not the regular services. Regular services have to be paid on the go. There is no provision at all which says that during CRP period you can accumulate CRP expenditure and pay it at the end of the CRP period when the resolution plan comes. But yes, practically many COC members feel like that. So
Yes.
that's something that I think came into this came into this judgment.
But then this is the repetition. So our experience says that all the IRP, RP liquidator, they should continue to pay the current dues. And in case they are not able to pay the current dues, then the supply would be discontinued. That's what is the law. And there should not be any further litigation on this, because there are many such judgments. Moving forward, we have this, yes, moving forward, we have IDBI Bank versus Ms. Mamta Binani, RP of Deccan Chronicles Holding Limited. And it is also a 3-bench judgment with the chairman, Sir Ashok Bhushan, and Justice M. Satyanarayan Murthy, and the technical member, Mr. Barun Mitra. Again, a very regular dispute regarding the dissenting financial creditor. So in this case also, the appeal filed challenging the order of the adjudicating authority, contending that the resolution plan submitted by Vision India Fund is illegal and discriminatory and in violation of the code and other applicable law. So the appeal was filed by the IDBI Bank against the RP, and it was basically that the resolution plan which has been approved by the adjudicating authority is illegal, does not comply with the regulations more specific to section 30 subsection 2, which provides for payment of liquidation value to dissenting creditors. So in this case, it was contended by the order of the A approving resolution is ignorant of the provisions of the IBC. It is contended that the adjudicating authority is ignorant of the provisions of the IBC, as the plan has grossly discriminated the financial creditor by providing less than the pro rata entitlement, being illegal. So being aggrieved by the resolution plan, the dissenting financial creditor objected and approached to the Honorable Adjudicating Authority. However, the same was dismissed, and hence the present appeal. So the dissenting financial creditor in this case was IDBI Bank, and the issues which were before the NCLAT was whether a dissenting financial creditor is entitled to claim relief under section 60 subsection 5, competent to challenge approval when the resolution plan has been approved and attained finality, whether the alleged discrimination overrides the commercial wisdom of the committee of creditors. If so, the order passed is liable to be set aside. Now let us see the observations of NCLAT. Now, in this case, the IDBI in fact was arguing that the value of my security is much more and the allocation made to me is lesser. The allocation made to me in the resolution plan is lesser. The IDBI was saying that the liquidation value which is due to me is higher, and the amount provided for me in the resolution plan is lower, and the rights of the dissenting financial creditor, that they have to be paid the liquidation value due to them before any other financial creditor is paid. That provisions are not there in the resolution plan. Therefore, the resolution plan is not legally compliant. Therefore, the resolution plan is not appropriate and should be disapproved. However, the adjudicating authority approved it. Now, what NCLAT said in this case, in most of these cases, what is happening, that no bench wants to disturb. Even the Supreme Court doesn't want to disturb the resolution plans which are approved. So once the resolution plan is approved, and maybe after 1 year of approval of the resolution plan, if any of such application comes before appellate authority or before Honorable Supreme Court, what should be the option? The one option can be that it should be told, yes, the liquidation value due to IDBI bank should have been paid, and therefore the entire resolution process should be disturbed. And secondly, it is also not very clear so far what is the liquidation value due to IDBI because of the pending matter before Honorable Supreme Court in the case of Technology Development Board versus Kotak Mahindra and the stressed asset. That's the case where Technology Development Board versus Anil Goel, that NCLAT judgment was appealed before Honorable Supreme Court regarding the interpretation of Section 53 regarding the secured creditors. And the issue was whether the Section 53 provides for the first charge, second charge, or subservient charge categories, and whether the Section 53 also provide for that the allocation would be done based on the value of security interest. Because the NCLAT said in this case that once the security interest is relinquished in favor of the liquidation estate, then in that case, all the secured creditors, they become pari passu and they should get proportionate to their admitted claims. However, the Insolvency Law Committee, Sidco Leathers versus ICICI, and so that is something which says that while distributing the proceeds during liquidation process, the first charge, second charge, subservient charge, and the value of security interest should be considered. Now, NCLAT in this case, he said the once resolution plan is approved cannot be withdrawn or modified under Section 63, subsection 5. Dissenting secured creditor cannot challenge an approved resolution plan in IBC and insist for payment of higher amount to it on the basis of security interest held by it over the corporate debtor. Adjudicating authority does not have power of judicial review when the decision taken by COC in compliance of Section 30, subsection 2 of and Regulation 37 and 38 of the IDBI regulations. It is not entitled to interfere with such decisions, except where the approved resolution plan is contrary to the provisions of IBC or any other law which would fall within Section 61(3) of IBC. Therefore, the appeal is liable to be dismissed. According to my understanding, if the dissenting creditors were not given the liquidation value, then the resolution plan was not compliant. However, the judgment says that the resolution plan now cannot be withdrawn or modified, and also the adjudicating authority does not have power of judicial review when the decision taken by the COC in compliance of Section 30, subsection 2. But Section 30, subsection 2 is not complied with. I'm only trying to say that till the time the issue is settled by the Honorable Supreme Court, it is not even clear whether the IDBI Bank is entitled to the value of the security interest, or IDBI Bank would say that the value would be proportionate to the admitted claims. So this judgment can be changed after the Supreme Court decision in the case of Technology Development Board versus Kotak Mahindra Bank. So
Yeah,
this
I think also I believe the timing is important, because in case a financial creditor is a dissenting financial creditor and he feels that the resolution plan that has been passed by the COC is not the plan, where does he go to? He might record, number one action is to record a dissent in the meeting of the COC members. Maybe in this case that might not have happened, because in case the meeting, in the COC meeting itself, a dissenting financial creditor records in the minutes of meetings that he has a dispute or he does not agree with the value given to him as a dissenting creditor, and therefore the plan is not in compliance with IBC, then other people would explain or would rather justify that no, the plan is compliant with the Section 53 waterfall mechanism. If that is not happening, then the next step is to file an application with NCLT before the resolution plan is passed, saying that I'm not getting my share as a dissenting financial creditor, so that the adjudicating authority can address that issue. I'm not sure if these two steps happened in this case.
I think these the processes are not there in the order. What we can say to all the dissenting financial creditors that they should try to resolve it till the time. They should try to resolve it within the COC, and because till the time the uh, Honorable Supreme Court decides on Section 53. Whether there is a separate category for first charge holder, second charge holder, and subservient charge holder, and whether the distribution would be based on the value of security interest of each secured creditor, that matter is pending. So, therefore, although that NCLAT order was stayed, where it was held that it has to be proportionate to the admitted claims, but that was stayed. But present law is the order of the adjudicating authority at Ahmedabad, which is in the case of Technology Development Board versus Anil Goel, and then the NCLAT order passed, and that was stayed. So therefore, the present law is the directions in the Insolvency Law Committee, which was the report was dated 26th of March 2018. And it was very clearly said in that report that the distribution would be done in this manner. Going forward, we have, yes, Ankit.
We can proceed.
You would like to add?
No, we should proceed with the next one.
Okay, Shri Ramachandra D. Chaudhary, resolution professional of Oasis Trade Link Limited versus Bansal Trading Company. Judgment is dated 1st September 2022, and it is from Justice Anant Vijay Singh and Ms. Shrisha Marla. So in this case, this is a case where multiple applications has been filed. So this is an application filed by the liquidator, and the liquidator wanted that there are many amounts which is recoverable from some debtors, sundry debtors, and the liquidator wanted that the application which is filed before the adjudicating authority for recovery, that should be proceeded against, because the liquidator said it is my duty to recover that as per regulation 39, and in case the liquidator would be directed to approach to civil courts instead of preferring suitable applications under section 60 subsection 5 clause B, then it would frustrate the time-bound manner in which the liquidation is to be conducted. Therefore, this is the jurisdiction. Therefore, NCLT is the jurisdiction. Therefore, the NCLT should pass an order for recovery of debt in favor of the liquidator. However, the adjudicating authority dismissed this application. Issue was whether the adjudicating authority has the power to pass orders under section 60 subsection 5 clause B of the code for recovery of the amount by the corporate debtor against sundry debtors. Now, in this case, NCLAT, of course, said that when it was rejected, but then let us see what kind of reasons was given by the NCLAT. Even I also feel that in case because this is something which is the process of liquidation to recover money, and we have in some cases got some favorable orders from adjudicating authority, but of late the orders are not coming. So the liquidators would be forced to go to civil courts, commercial courts, and even the negotiable instrument courts for the recovery of sundry debtors. Now, let us see the arguments given by NCLT while giving the decision. The appellate authority says that the RP is required under section 18 of the code to take control and custody of the assets of the CD. The amounts stated to be due and payable to the CD by other sundry debtor are required to be included in the information memorandum. And when included, the person, entity purchasing the assets of the corporate debtor would have knowledge of the value of the assets, liquidation value as stated in the information memorandum. That's very clear. That is something which is for the CIRP period. And I think this particular application was submitted by the liquidator. So for the liquidator, the information memorandum and that too under section 18, that we couldn't understand. In view of the ratio in Gujarat Urja Vikas Nigam Limited versus Amit Gupta, the remedy for recovery of debts disputed or not cannot be determined in summary proceedings, and the code does not contemplate adjudicating of any such nature. Any such steps taken under section 60 subsection 5 of the code before the adjudicating authority would tantamount to bypassing, short circuiting the judicial proceedings. So that was the judgment in Gujarat Urja Vikas Nigam. Appellant is well within its power to take appropriate steps to file legal proceedings if the circumstances so warrant. The code expressly provides for the liquidator to institute or defend any suit, prosecution, or other legal proceedings, civil or criminal, in the name or on behalf of the corporate debtor. The ratio of Supreme Court judgment in the case of Embassy Property Development Private Limited versus State of Karnataka is applicable to facts of the appeal, and therefore there is no illegality or infirmity in the directions given by the adjudicating authority. So it's more or less this first paragraph of the observations I couldn't understand. However, the Gujarat Urja Vikas Nigam Limited and Embassy Property Development Private Limited, it was somehow the Supreme Court said that there is private law and the public law. So there are, when there is a public law, then it has to go to the appropriate structure which has been made in those laws. Like suppose there is a recovery from Income Tax Department, Custom Department, then it has to go to that special departments and the adjudicating structure in those departments. However, in case the other party is a private party, then the jurisdiction lies with the adjudicating authority. However, in this case, the adjudicating authority denied, the NCLAT also denied. So this is something now, I think it has become law that this Oasis Trade Link Limited case, Ramachandra D. Chaudhary, this is a kind of case where the no such cases may be filed before NCLAT or adjudicating authority for such kind of recovery processes. So anything, Ankit, that we can take up now?
Yeah, so liquidator has to go and look at options, other legal options. The option under section 39 or regulation 39 rather, to go to NCLAT is to NCLT to get directions or to do something there is not applicable. So the merger that we always thought that IBC merges all the litigation to one court so that all litigations can be done here. Seems to be not the inclination of the judiciary here, or rather the inclination of NCLT here.
Right. See, next judgment is Bhavani Shankar Harish Chandra Sharma versus Feedback Highways OMT Private Limited. Again, 2nd September 2022, and the judicial member Justice Rakesh Kumar Jain and the technical member Alok Shrivastava, they have given this judgment. It was an application under section 9, and the application was made by Feedback Highway OMT Private Limited against Supreme Infrastructure BOT Private Limited, and the amount was 1 crore 18 lakhs of rupees. The OC issued demand notice in terms of section 8 along with the invoices, statement of outstanding, and filed an application under section 9, which was admitted. The order passed by the bench had 2 judicial members and no technical member. Irregularities were present in the manner of pronouncement and mode of delivery of the order, as one party was not informed about the listing of the matter, and on the same day the order was delivered. Hence, the appeal is preferred. So the appeal is preferred against a section 9 application, which was admitted. It was admitted by 2 judicial members and some other irregularities, which actually said that the notice was not, one party was not informed. Issues whether the IRP can be appointed when no proposal for the same is made by an operational creditor in its application, whether a member of the bench who has not heard the arguments can pronounce the order of a reserved judgment, issue of period of limitation. Issue of period of limitation was also there. Now, the NCLAT in this case has held that whether the name of the RP, when the name of the IRP is not proposed, and where the application for CIRP is made by an OC and no proposal for an IRP is made, the adjudicating authority shall take reference to the board for the recommendation of an insolvency professional who may act as an IRP. Very clear. This has been This is happening every day. While addressing the second issue, NCLAT observed that the odi alterum partem is a salutary principle of natural justice, which means that nobody should be condemned unheard. Referring to Rule 150 of the NCLT rules, which provides every order of the tribunal shall be in writing and shall be signed and dated by the president or members consisting the bench which heard the case and pronounced the order. With regard to the third issue, the admission order dated 10th of January 2018 was not passed in accordance with law and was not pronounced to make it known to parties concerned, and merely the fact that there is an endorsement on the copy of the order dated 10th of January 2018 that it has been given free of cost does not indicate that it was given to the appellant. It was only an order of admission in which the adjudicating authority has observed that it would pass a separate order for the appointment of the IRP, for which the registry was directed to write to IDBI for making the recommendation of the name from the panel of the IRP. No recommendation was made by IDBI, and the respondent itself was in dark about the proceedings before the adjudicating authority regarding the appointment of the IRP to initiate the process of section 13 and 14 of the code. The IRP was ultimately appointed by the AA on 25th of February 22, and the present appeal was filed within no time by the appellant before this tribunal, not only to challenge the order dated 10th of January 18, but also the order dated 25th of February 22, which is, as a matter of fact, an order passed in continuation of the order dated 10th of January 2018. Because mere admission of the application filed under 9 of the court is no consequence. The appeal filed the appellant is well within time of the jurisdiction, even against the order dated 10th of January, because the said order was never pronounced to the knowledge of the appellant and by the bench competent to do so, and as such, it could not have been challenged by the appellant earlier within the time prescribed under section 60, subsection 61. So in this case, the NCLAT said that the section 9 order was passed. It was having two irregularities. First thing that they said that the IRP has to be appointed like this, even if it is not proposed by the OC. Secondly, it said that the order has to be passed. The order has to be passed by the bench which has heard the case, and it has to be pronounced by the same bench. The third thing that the NCLAT has held, that the time of limitation that actually will start from the date of appointment of IRP and not from the date of when the order was passed for admitting the case for CIRP, because the admitting the case has got no consequence till the time the IRP is appointed and the control and custody is required to be taken. So if there is an order which says that the CIRP start, but then there is no IRP appointed, that order has got no significance and would not have any impact. Therefore, one, IRP is appointed, okay. Second, the limitation is accepted because the limitation will start from 25th of February and not from 10th of January. And the third thing is that the order which is passed by which should have been passed by the bench, which is an appropriate bench. So I believe the competent to do so, and as such, it could not have been challenged by the appellant earlier within the time prescribed. So these two things, since they challenged it, the jurisdiction, the limitation was in their favor. The bench was also not a regular bench. Therefore, the section 9 application, which was admitted, that was quashed.
But then this provision of referring this to the board was an older provision. Now I believe they have a list, and then they're supposed to just pick somebody from that list and pass or name the IRP in the order itself. But this, since they're here, the original judgment is dated January 2018, a very old one. Therefore, this complication or this duality might have occurred.
Yeah. I think we can go to the next judgment. Ravi Kumar Tomar versus Newgen Speciality Plastic Limited, a judgment dated 22nd of August 2022 by Justice Rakesh Kumar Jain and Ms. Shirisha Marla. This judgment is again respondent, the OC made supplies to corporate debtor during CIRP. Post commencement of CIRP, no payment was made by the CD of the operational creditor with respect to those supplies. Now, the corporate debtor placed purchase order for the supply of ice box and carrier frames for a sum of rupees 4 crores. Operational creditor successfully carried its contractual obligation and issued invoices. The corporate debtor accepted the invoices and made part payment. No dispute was raised about the invoices. Last date for the icebox and carrier frame was delivered on 15th of March 2019, and since the payments were not being made, it called upon the CD through notice to pay a sum of rupees 27 lakhs. Total supply 4 crore 67 lakhs. The order was placed during CIRP. That means the order was placed with the consent of the IRP. And then the part payment was made, and finally 27 lakhs were pending. The learned adjudicating authority has observed that the OC had made supplies to the corporate debtor during the time when it was going through CIRP, and no payment is made by the CD post commencement of CIRP of the operational creditor with respect to those supplies. Hence, application under Section 9 of the code filed by Newgen Speciality Plastic Limited was admitted on 24th of December 2021. So that actually means that particular CIRP must have been withdrawn. The earlier CIRP must have been withdrawn, and the payment was due, 27 lakhs was due. And then finally, the adjudicating authority said, yes, this is the right application under Section 9. The amount was not paid. This 27 lakhs has to be paid. So therefore, whether the advance paid to the operational creditor before the commencement of CIRP of the operational debt can be adjusted towards the supplies made to the corporate debtor during CIRP by the operational creditor. Contentions made by the appellant after initiation of CIRP against CD, supplies were made by it for creation of the liquidity in order to run the company, and it cannot be adjusted with the advance given before the initiation of the CIRP. In case of adjustment, it would be transfer of the assets of the corporate debtor on account of an antecedent debt to a creditor, which shall be preferential transaction, and the same has been frowned by the tribunal in the case of Binani Industries Limited versus Bank of Baroda. Now, in this case, the NCLAT said the operational creditors made supplies to CD during the time when it was going through CIRP, and no payment is made by the CD post commencement of CIRP of the operational creditor with respect to those supplies. The advance has been made against the same purchase order, therefore it deserves to be adjusted. No error in the impugned order for the purpose of interference, and hence the present appeal is hereby dismissed. So the advance was also given for the supply, so that was adjusted. So I think, Ankit, we can close this. The time has already moved up, so we should close this. And I think these are the judgments that we could discuss.
Right.
I think anything which is relevant to this judgment, if there is any question that we can take up.
Not really. Not really. There are other questions, but they are not relevant to this judgment and these judgments. And I believe we have very thoroughly discussed these judgments. I don't think there is any question that can be taken up with respect to these judgments.
Great. Thank you very much, all the participants, and you motivate us. We get motivated, and this process should continue. And as I always say, that this is our way of learning. Thank you very much.
Thank you, everyone. Thank you.